Be David Hunter, from professor from American University, United States. It's your.
Thank you, Chairman, and thank everybody for being here, and I thank the organizers for what is a truly important and timely event. I want to speak a little bit about the Paris Agreement, maybe make a few comments about the Oslo principles, but I mostly want to speak about the role of courts in remediating climate change, doing what courts do, remedying for the victims of climate change, and talk a little bit about that for something different rather than mitigation. First, so I'm going to ramble a little bit. I apologize, but that's my usual approach. I wanted to comment about the Paris Agreement. I thought the history and the overview was terrific. Thank you for giving us that context. And say, you know, in the environmentalist community, the Paris Agreement was greeted mostly with great joy. There's always some criticism, but I think that criticism comes from over time we've kind of forgotten how fundamentally difficult it is what we've asked governments to do in negotiating climate change. This is a really difficult. When we started off in the early 1990s, I think we underestimated what we would be asking governments to do to completely restructure the nature of their economy through negotiation. It puts a lot of weight on environmental diplomacy. And the original view of how we were going to do that with science under the Framework Convention and Kyoto Protocol concepts, that science would provide an understanding of the cap, and then we would allocate it among all the governments somehow, including through a trading system. But there was just going to be this cap and trade, but really a cap and allocation system. And again, I think this is a lot of weight to put on environmental diplomacy and to get governments to be able to agree. And this proved to be true over time. In my country, we couldn't ratify the Kyoto Protocol. Political shifts in the United States, the thought, now we find this kind of naive, the thought at the time when the Kyoto Protocol was negotiated in 1997, that we would be able to negotiate an international agreement and bring that home to the United States, where the United States Congress would readily accept it, and we would pass a law and do all that sort of thing. And we once again found out that the United States goes its own way too often. But the shift in Paris that really started in Copenhagen, this shift to a more bottom-up approach, the pledge and review approach, as opposed to the cap and trade. What really allowed us to be successful in Paris is that we ignored the allocation question. We've endorsed as governments the long-term goals of 2 degrees and perhaps 1.5 degrees. So in essence, we've agreed to continue to have the cap motivate us, but rather than the very difficult part of the diplomacy of allocating across countries, who gets to emit what, how fast do we get to develop, essentially, how fast do we have to change from our energy systems, that was just too much to negotiate. So this idea of individual pledges and national determined commitments, this really allowed us out of that gap, that problem, smartly, I think. It allows us to move forward in many positive ways. It allows us to build the institutional structure around these national commitments. We still have the gap between ambition and what science is telling us that we have to do, and we also don't have to all agree on the allocation up front. I'll come back to that in a minute. But what I think is interesting also about the Paris Agreement, just holistically, in addition to that, is, hold on a second, I just want to get is I think also the signaling quality of the Paris Agreement, the signaling quality to the long-term economic shift that we're seeing take place was maybe the most important thing that came out of Paris, with all the governments of the world now unified in taking responsibility for climate change. As Yolanda Kakabasa said earlier today, coal and fossil fuels can see the end of their rain, and we see this as well in the pricing. I was reading The Economist magazine on the plane over here, and the pricing of solar power now, the last bid was $40 a megawatt. It's going way down, and it's going to continue to go down. I think we haven't seen the bottom of it. And this is in a time when oil prices have dropped and coal prices have declined. So I think we're seeing quite positively the shift from financial factors and from the policy signal that's being sent now very clearly from all countries in the Paris Agreement. I think that's remarkable. But I think the allocation question will nag us, and also because it brings us up to questions of climate justice and equity and equality, and I think those issues are the ones that the Oslo Principles, just to bring those in a little bit as we were directed to, I think that's what the Oslo Principles continue to provide for us. They provide a way of looking at and not forgetting the allocation question. That really the only way you can allocate the rights to the atmosphere, the rights to be able to pollute, is on a per capita basis. And once you decide to do that, it has profound implications for what different countries and different aspects will be over time. And if we take the cap that science gives us and the rights-based approach to a per capita emissions criteria, then you can start to use this as a benchmark, both to measure whether countries are equitably taking their share, but also perhaps in courts, since we've got a lot of judges here at the conference. When courts are asked the question, as they will increasingly be asked, has our government done enough? The Oslo Principles can provide a benchmark for that as well. How do we measure what the fair share of each country is? And have they taken the steps that they need to meet the cap? How to allocate that. And I want to speak a little bit about the role of courts and in another area, and that is to speak about the damages from climate change. It's sometimes not polite to talk about the damages of climate change. We want to focus on mitigation, and we want to focus on solving the problem, and I certainly want to solve that problem too. But we need to be talking about how to address the damages from climate change and how to remedy the victims of climate change. Much of that discussion internationally is now focused on the loss and damage discussion between governments, but I don't think that's the only or perhaps even the best place to discuss this. Let's be honest, the United States is never going to accept a legal formula in a negotiation that's going to at least hold them legally responsible for climate change. They may do things through assistance and development aid, and that would be fine. But that doesn't really leave the room for the courts. But I'm very interested in civil liability and the liability of companies. We've kind of accepted the fact that we're all somewhat responsible for climate change. We all drive cars, we all make choices that many of us flew long distances to be here. So we all feel a little equally responsible. But some of us are more responsible than others in the private sector. And I speak specifically of the fossil fuel companies. And I think there's, certainly in my country, there's a renewed interest in looking at the history of the fossil fuel industry and its approach to climate change. And I'm seeing it in judicial, in the beginnings of litigation in other countries as well. And if we think about somebody who's harmed by climate change, who has economic loss in climate change, there's a lot of barriers to bringing any actions against a company. Let's take ExxonMobil as an example, since it's the #1 corporate emitter. I'll come back to that in a minute. We would first think about the obstacle of causation. This is what courts are going to be wrestling with. Can you scientifically show that your injury was caused at least somewhat by climate change? The science of attributing particular events to climate change is becoming much better. There are very serious studies on many different impacts of what the added impact on the Western drought in the United States or the drought in France a few years back. What's the percentage that was worse because of climate change? It varies, 20%, sometimes 30%. Was Cyclone Winston worse because of climate change? These are questions that experts are wrestling with and increasingly being able to answer. So we can attribute some of the impacts of specific events to climate change, or at least we could have expert witnesses on that. what's the contribution of the company, of a company? Well, according to a long study, took several years by a fellow named Rick Hida in the United States, he looked at the major fossil fuel companies, coal and oil, and looked at their historic contribution to climate change. Now, we can argue about the methodology, although it's pretty sound and it took a long time to do it. It was a peer-reviewed study. And the percentages for ExxonMobil and Texaco Chevron, the two largest historic emitters, were slightly around, right around 3% each. ExxonMobil slightly a little bit more. 3% of all historic greenhouse gas emissions could be attributed to that one company, or 6% for the two companies. That would place them 7th or 8th on countries, if they were countries. We always think about climate change from countries, not from companies. Well, still, we all bought their product. What did they do wrong? What did they know? When did they know it? And what did they do about it? That's the question that I think we'll be asking ourselves more and more. We'll be asking judges and courts to look at it. Well, what did they know? It was ExxonMobil's business to know everything about oil. They knew it all from the 1940s to the 1950s on. And an increasing number of documents are coming out. Just 2 weeks ago, the Center for International Environmental Law released a document that was, several documents, there are more to come, that in 1960, but one document's interesting, I'll use it as a highlight. In 1968, think about that date, I was 7 years old. 1968, ExxonMobil received a memo from their own scientists, basically outlining climate change as we know it today, with all the impacts, and making a recommendation. They had, by the way, back to the 1950s, similar reports, but this one is interesting because it recommends to ExxonMobil that they take, that the first recommendation they have is that they start researching technologies that could reduce the emissions from fossil fuels. 1968, 50 years ago. 30 years before, or 25 years before, we meet in Rio to do the Framework Convention. Think about where we would be from a climate perspective if that information that they knew, if those technologies that they were being recommended to be developed were actually starting to be developed then. We would be way ahead of the game. What did they do instead? Well, they ignored that recommendation. They had other documents at the same time that described carbon dioxide as a significant pollutant and a problem for their industry. So what did they do? They lobbied against having carbon dioxide be listed as a pollutant under the Clean Air Act. They formed coalitions in the 1990s to obfuscate the science and to look at other alternatives for man-made climate change, even though they had these, and I've only mentioned one document, but there's a lot of documents about it. So they knew, and they knew in fact so well that by the 1980s, they were forming, both on the one hand, this public relations campaign to talk about how climate change could be being caused by anything. Solar radiation, sunspots, these were all parts of their effort. And at the same time, internally, they were developing investment strategies for how to invest in the Arctic as ice would melt. So their investment strategies were taking climate change very seriously, while externally they were telling us not to worry about it and obstructing policy progress. Again, where would we be if 50 years ago they'd taken a more responsible approach? Now, I just wanted to highlight those couple of documents because what they knew was a lot more than the general public. When they knew it was a lot earlier, and what they did about it was either ignored it or worse, hid it. And this has gotten the attention of state attorney generals in the United States. 4 states attorney generals have already announced that they're subpoenaing more documents, or at least one is subpoenaing them in New York, to look at it under consumer fraud and investor fraud failed to disclose. So we'll see where those go, but I think it's very interesting. I think there's more documentation to come, and I think it's going to ask courts to do what courts do best. Look at somebody who's been harmed, and look and see whether somebody caused it, and then make compensation for it. I think it's a very interesting time to be looking at these, and I welcome your engagement on this new front. Thank you.
Thank you, David. Following the speaker order, Now it's my time to talk about. So I'd like to end the PowerPoint. First, I'd like to congratulate and express my gratitude to our organizer, Mary Maria, that is here. My talk today is aimed to analyze some legal aspects of biofuel production in Brazil, mainly the ethanol, highlighting the contribution of the Brazilian Superior Court of Justice case law to the matter. Next one. In order to do so, I will first briefly analyze the most recent climate change agreement, the Oslo Principle, the Brazilian Climate Change Policy Act. In this context, I will give you an insight about the positive and negative aspect of biofuel production in Brazil, highlighting the main legal issues connected to it, with emphasis to its relation with the best available technology and the precautionary principle. I will therefore conclude my presentation talking about the environmental hermeneutics applied by the Brazilian Superior Court of Justice on its ruling, highlighting the court's case regarding the precautionary principle. Next. It's well known that the climate change is one of the most concerning issues of the Anthropocenic era, whose drastic consequences severely impact our human economy, social and environmental system, causing biodiversity loss, extreme weather events, energy insecurity, degradation of ecosystem service, and degrade of human well-being. In this context, the Paris Agreement, which will succeed Kyoto Protocol, was adopted last year during the COP21. The agreement will bind all parties, setting commitments to halt the climate change. In this sense, the agreement foresees the countries should increase the annual climate finance to $100 billion by 2020, and also present every 5 years new climate action plan to reduce the emission, seeking to hold the increase in the global average temperatures to well below 2 degrees Celsius above the pre-industrial levels. Next. The precautionary principle, given this background and within this context of crisis, it's relevant to take a look at the principle whose guidance can be extremely helpful to the analysis of the emergent legal issues. I'm going to therefore give a special attention to the precautionary principle and the obligation of the adoption of best available technology. It is undeniable that the precautionary principle when dealing with the scientific uncertainties regarding a more environmental protection. The principle is closely linked with the idea of being careful, and it aims to reduce risk, bring security, and ensuring environment sustainability. The precautionary principle mitigates legal uncertainties within the risk management and cannot be understood as a cause of stagnation or blockage of scientific development, but rather as a way to allowing scientific progress within the planet's biophysical limits. It does require the adoption of anticipatory approach in the management activities of the company and of the states, requiring the urgent regulation of hypothetical risks when they are unproven. For that reason, on March 1st, 2015, a group of eminent legal experts concerned about the global climate and its tragic threats for the entire biosphere produced the Oslo Principle on the global climate change obligation. The experts so started that there is a clear and convincing evidence that the greenhouse gases emission present a series of irreversible risks to both to present and future generation and all forms of life, would emphasize the need of lawmakers, policymakers, judges to observe the precautionary principle and base their decision about it. Next. The Oslo Principle, as we see in these slides, show the contents of the precautionary principle. Moreover, they establish that the acts required by the precautionary principle should be adopted without regard the cost, unless the cost is completely disproportional to reduce the emission that will be brought about by the expanding it. The document also establishes the obligation for states and enterprise, point out the need of promoting the elimination of broad fossil fuel subsidies. It is thought that the state have more access to renewable energy, such must be emit less greenhouse gases. It is important to point out here that according with the international documents on the climate change, such as those mentioned before, and the commitments assumed by Brazil to reduce the mitigate its effect, the country established the National Climate Change Policy Act in 2009, implementing a new voluntary commitment action to mitigate greenhouse gases emission aimed at reduction then by 2020. However, there is a lack of systematic, strategic, and enforcement concerning this policy. Next. In this context, we can also talk about the adoption of the best available technology, which can be understood as a consequence of the adoption of the precautionary principle. The best available technology should be balance all the interests involving the costs and the benefits. It is necessary to highlight here that the imposition of the adoption of the best available technology gives an important role to environment management, identify what means the techniques and at any time can be considered the best. In this sense, the best available technology can be considered as a kind of preventive measure, which applies to protective and precautionary principles and give a scientific parameter to the legal interpretation. Therefore, is to constitute a way to reach a balance between scientific progress, economic development, and environmental protection. The adoption of the best available technology, therefore, allows us to choose more sustainable biofuel production techniques in Brazil in order to satisfy the need of the present and the future generation without compromising future ones. As we can see in the next, we can see in the Brazil energy matrix, biofuel, mainly ethanol, represent an important share of the Brazilian energy matrix, with about 16% of the sugarcane production. Now I'm going to talk about the positive and the negative aspect of ethanol. The production of ethanol is considered the renewable energy source, offer many benefits such the reduction of greenhouse gases emission, and crops absorb CO2, and the combustion of the ethanol is less toxic than the combustion of gasoline, which produce several negative side effects. Likewise, the ethanol has a high capacity to provide renewable energy when related to the other biofuels, being the Brazilian sugarcane, the most efficient biofuel existent today. Furthermore, the development of this sector promotes the creation and maintenance of many jobs in all stages of its production chain, which start with the plantation of the sugarcane and end with the delivery of the fuel of the final consumer. Next. The graphic here shows the area cultivated with the sugarcane in the country has increased approximately 73% from 2000 and 2008. The question we can raise is the following. However, we may ask ourselves a couple of questions. Is sugarcane production clean, sustainable, and truly renewable? What we can observe is that the sugarcane production has in fact a negative side, and it has many impacts on the environment, being necessary the discussion of its role on the biofuel production. Next. It's important to point out that the process of growing and processing sugarcane pollutes the soil, the water source, as amount of chemicals are used. The other negative aspects are the deforestation, biodiversity loss, the large amount of land monocultures, insufficient remuneration, and critical workplace conditions for the workers. Moreover, although the burning of the sugarcane facility, the harvest, these practices destroy the soil, pollute the air, and cause respiratory diseases. The processing of the sugarcane in factories also pollutes the air through the burning of bagasse, which produce smoke and salt. For instance, the National Institute of Space Research has emitted an alarm for the state of São Paulo, the country's largest sugarcane producer, because the burning in its territory led to the extreme lower humidity level. Next. Now I'm going to deal with the generation of biofuels. Given all that, we believe that although the present scenario is predominantly characterized by first generation of biofuels such as sugarcane, the production of the second generation of biofuels should be placed in order. There is no doubt that the production of fuel out of biomass waste is the way to go. It is the best available technology today. It's the main advance is the fact that it will be not compete with the food production, since the source comes from agricultural waste, which partly solve the land use problem. There are diverse raw materials that can also be used for fuel production, such as manure, food waste, wood, straw, forest research, and other, among others. It's also important to highlight here that the energetic potential of the second generation ethanol made out of sugarcane is impressive. According with the researchers, find a way to reduce the cost of the production. The use of the 2/3 of the sugarcane cellulose could, in long run, dramatically increase the production of the Brazilian ethanol. Next. Now I'm going to highlight the STG's new ruling on the precautionary principle. That's important for us in Brazil, because there is a chance in the courts that's quite important to know how the court is dealing with that. I can say that being said, it's important to stress that according with the Brazilian Superior Court of Justice modern understanding, the precautionary principle implies at the reversal of evidentiary burden, which means that who apparently promote a given environmental damage must prove that the damage was not caused by him, or that the substance released to the environment is not likely to damage. Also, the court understands that the principle can be used to suspend the construction of a property in case which occasionally damage could be irreversible. In order to declare the suspension, 3 elements must be verified. First, risk of damage. Second, irreversibility of the damage. The third, scientific uncertainty. In this sense, holding any environmental license does not grant their owner a right to pollute or degrade the environment by the license. If the 3 elements are verified, the construction can be suspended. Moreover, the court comprehends that the environmental damage can cause collective moral damage, according with the recent decision that also show that the constitutional